While we're waiting, I will first off note that we will have our next food court event on March 9th. And that will be kind of a special food court event because instead of focusing strictly on a legal topic, we'll be looking at celebrating International Women's Day. And so we will be kind of focusing on some of the issues surrounding what females in the legal field have to deal with and the struggles that they encounter, and also the successes that they've made and the progress they've made over the last years in the legal field. So that'll be exciting, and we are really looking forward to that opportunity. Okay, we'll go ahead and get started here. I want to welcome everyone. My name is Philip Palmer, and this is Food Court. We want to thank everyone who's joining and those who continue to join. We have an exciting panel today. We have Justice Vaughn, Judge Smith, and Judge Bowles, and Tom's going to introduce them, and Mr. Connolly is going to be our moderator for today. So I will go ahead and turn it over to him as we talk about what you need to know for your first court appearance. So go ahead, Tom.
Awesome. Thank you, Phil, and welcome everyone, and welcome judges. Thank you for your time today. First, I'll introduce Justice Barry Vaughn. Justice Barry Vaughn is an appellate court judge who has served as a judge for nearly 20 years in his 30-plus year legal career. He was nominated by Supreme Court Justice David Overstreet to the 5th District Appellate Court and was unanimously approved for the appointment. He was first elected to the Second Circuit in 2002, where he handled every kind of case and earned a well-deserved reputation as a tough but fair jurist. Judge Vaughn was previously the youngest state's attorney in Illinois, serving 8 years in that capacity in Wayne County. He also spent 6 years in private practice as a partner in Cochran and Vaughn, and prior to that earned his Bachelor's of Arts from Southern Illinois University and his JD from Southern Illinois University School of Law. Judge Vaughn has been married for 32 years to his wife, Kimberly, and have 3 children, Grant, Landon, and Kylie. So thanks again, Justice Vaughn, for joining us today.
Thank you for having me.
Next is Judge Susan Clancy Bowles. Judge Bowles is serving as the presiding judge of the Civil Division of the 16th Judicial Circuit in Kane County. She's a graduate of Vanderbilt University and Valparaiso University School of Law, where she graduated with high distinction. She was appointed as an associate judge in 2007, and then in October of 2008 was appointed by the Illinois Supreme Court to the position of circuit judge, and was elected to circuit judge in November of 2010, and served as the chief judge in 2015 through 2019. Judge Bowles was one of only 15 judges across the state who served as an original member of the reconstituted Illinois Judicial Conference, and in 2019 assisted in advancing the conference's strategic goals of professionalism and accountability throughout the judicial branch, and was appointed to serve as a chair of the Judicial Administrative Task Force for the Illinois Judicial Conference. Judge Bowles serves by appointment of the Illinois Supreme Court on the executive board of the Lawyers Assistance Program and the Judicial Mentor Committee. She is also a trained facilitator for the Illinois Judicial Performance Evaluation Program. And thank you, Judge Bowles, for joining us.
Glad to be here. Thank you.
And last but not least, Judge Sarah Smith is a circuit judge in 3rd Judicial Circuit in Madison County, where she is a lifelong resident. She's been serving as a judge since 2015 and is assigned to the Civil Division and is the presiding judge of the Veterans Treatment Court and handles criminal and post-conviction matters as assigned as well. Prior to that, Judge Smith worked as a prosecutor in the Madison County State's Attorney's Office and had a 10-year career as a civil litigation plaintiff's attorney. Judge Smith is a colonel and serves as the state judge advocate in the Illinois Army National Guard. She's a 2020 graduate of the U.S. Army War College, and she was appointed the first female military judge in the entire Army National Guard. Judge Smith has 27 years of military service, including 2 combat tours. So Judge Smith, thank you for your service and thank you for joining us here today.
My privilege. Thank you for having me.
So today's discussion, as everyone can assume from the topic, is geared towards newly admitted attorneys to kind of help them best prepare for, their first court appearance, as well as, their first handful and few months of practice. So they know what to expect and how to address issues that may arise. I think it's also a helpful discussion probably for law students and probably attorneys like myself who've been practicing a few years and might need a refresher on a few things because that we know that never hurts. So I will go ahead and get started. And I think I will start with an easier question. And I will ask Judge Bowles, can you just tell us about proper courtroom attire and appearance for when appearing at a case management conference?
Sure. I will say, especially in today's world where we have a lot of virtual appearances through Zoom, courtroom attire, we've seen a lot of different things. It needs to be a professional attire, whether you're on Zoom, whether you are in the courtroom or not. So that, to me, that means a coat and tie. That means not putting on your coat, not tying your tie as you're sitting in front of a Zoom camera. It means ready to present just like you were standing in front of the judge in a courtroom. I think I speak on behalf both of the justice and Judge Smith as well. We've really seen a lot in this last year and how people feel it's okay to appear in court. And quite frankly, sometimes behavior follows the dress code. And so what we have found is that there is a formality to a courtroom and that formality should be respected. Everybody doesn't have to come in black tie attire by any means, but they need to be dressed professionally and observe the respect of the courtroom, whether they're virtual or in the courtroom. Judge Smith, Justice, do you agree with that or do you think differently?
I agree with that 100%. And I, as a trial judge for 18 years, for the most part, people came dressed appropriately. A few times I saw people come to court without a tie, sometimes without a jacket. And usually I let them argue the case. And then when it was over, I'd say, I need to talk to you back in chambers. And I didn't want to embarrass anyone in front of their client, but I would take them back in chambers and I'd say, do not come this way again. I expect you to come with a coat and tie to court. This is court. You're respecting the court, not necessarily me, but you respect the proceedings. And it just makes a good impression for your client too. If your client is with you, they expect to see someone who looks the part. They don't expect someone to come in disheveled. So, and I've been surprised on the appellate court. We do all in the 5th district where I am in Mount Vernon. We do all our arguments on Zoom still. I think the Supreme Court's back live in-person arguments, but down here in our area, we're doing stuff by Zoom still. And I've been surprised. We provide a virtual background to the attorneys and require that they use it, but we still have attorneys who appear with their office background. I'm using my office background today. We're more informal today as a meeting, but we have attorneys appear with their desks in the background, mounted over with papers and empty McDonald's cups in the trash can and just doesn't look professional. We had one case earlier this year where an attorney appeared in his car. He's holding his phone up. He's not wearing a suit and tie or a jacket and tie. He was just wearing a regular dress shirt, but no tie. And you can tell he's obviously in his car arguing. And I'm thinking, we still pay attention to the arguments, but I'm thinking, did you not respect appellate court? This is a big deal for your client's case, and this is how you appear to represent them. So we still try and decide the case on the merits, but you don't want to do something that's distracting. You don't want to have things in the background that are distracting. I've closed my door. I told my staff today, I'm in a Zoom meeting, the door's closed, don't barge in, don't come in. You don't want anything going on in the background that's going to distract from your arguments, whether that's your appearance or other things in the background. You want the focus to be on what you have to say in your argument, not your appearance or something going on in the background.
And
Yeah,
Judge
just
Smith,
to chime in. Sorry, just to chime in, I would agree wholeheartedly with that. And unfortunately, in Madison County, we don't have the formal background, but it is very distracting. I had one attorney show up and his messy bed was behind us. I mean, he was literally in his bedroom. So be very cautious about what your backgrounds are. And also we've had attorneys who want to get creative with their backgrounds. I mean, we've had cats in the background, different things. And it's, while it may be amusing to your fellow colleagues, it's really not, when you're dealing with it on the bench. The one caveat that I might say to Justice Vaughn, and only because I had to experience this as a kind of a working mother with my husband deployed during COVID, where I was also remote learning, while we agree wholeheartedly, keep the distractions to a minimum. I do think that probably all three of us would also understand there is sometimes, I think we've all seen the Fox News or whatever news story it was, where a little toddler came running into the, background. We understand that as well, but we just try and keep the distractions to a minimum.
Thank you very much. Justice Vaughn touched a little bit about seeing someone do a appellate oral argument from their car. Judge Bowles, what would your position be on an attorney doing just a status conference from their car? Would you rather see them be somewhere more professional?
Again, yes. It's disturbing, not only from the court side of it, but also for whoever is around that person in the car. I had one person that was actually moving at the time, and I said, all right, why don't you go ahead and zoom out and stop your car? I could see things changing in the skylight. So I think, again, it's part of the respect, it's part of the decorum for the court, for the proceeding, to take the time and focus on what you're doing before the court at that moment. And to sit in a car, and it usually involves a different dress code as well in the car. We provide here up in Kane County, and I don't know if this is true in central and southern Illinois, but we have rooms where people can go and come into the building and Zoom if they're not in the actual courtroom. So we provide some of that basis. Again, I agree with Judge Smith. There's always going to be exceptions if somebody's in an emergency situation and they don't want to miss an appearance. But otherwise, I think the general rule is they need to be somewhere, not in a hallway. I've also been having people in a hallway and Zooming, and that's extremely disruptive as well. Somewhere where they are by themselves or sectioned off and Zooming in.
And in the worst case scenario, I would always, if there is an emergency situation where you are out of, in a different area, at least ask the judge for permission, maybe just to be on audio only, because I would much rather hear audio than seeing a bunch of background distraction.
Mm-hmm.
And that's a good topic, Judge Smith. I do see attorneys a lot of times will be appearing just with audio or with their screen blacked out. Is that something that you judges would like to have attorneys ask you beforehand?
I would say absolutely, Judge Bowles.
I would say the same thing. I think generally, if I would ask, is there a reason why you don't have your video on? Because I think, again, it's somewhat distracting. But if they're in a situation where, for whatever reason, they can only be using audio, then I'm fine. If this is a unique situation, I'm fine with that.
I would like to address it ahead of time. In the appellate court, we want audio and we want video as well as audio. But when I was a trial judge the last 2 years, when COVID came along, a lot of people appeared by audio only, and sometimes they would start with video, and because of low bandwidth down here in Southern Illinois, sometimes the court reporters would have lag. If we're doing a proceeding that's having a record with transcribed, the court reporter would ask sometime, could you turn your video off so it's just audio so I don't have lagging? So, but we wanted to talk about that ahead of time so we know what's going on and why we can't see the other person. I mean, the old story about when you're in court, there are cases that talk about if you're hearing a custody proceeding and a new judge substitutes in, you can't just go on the transcript because you have to see the person testifying, see their demeanor, so the same with an attorney making an argument in a case. You want to see the attorney, how they're phrasing the arguments and how their demeanor in general. So I think, generally speaking, I would rather see video. Now, I would probably make an exception in a case management conference where you're just picking dates or continuing it for another date, and I wouldn't be such a stickler on have to see video, but you should ask the judge ahead of time. I feel quite confident saying most judges would prefer that.
And along those lines too, always, even if you're on video, if you have someone else, let's say your client or somebody in the room, but we can't see them on the screen, please make sure you just give it as a courtesy to the judge and say, okay, judge, by the way, but you may not see them, but my client is sitting here as well, because we as judges kind of want to know those things as well. So that's just kind of a courtesy.
Great, thank you. In addition to dressing proper, the next thing is being properly prepared for a court hearing. Judge Smith, I guess we could start with you. Could you just kind of give your advice to a new attorney on how to properly prepare for a status conference or appearing before you?
Absolutely. And I'm sure a lot of the things that the other judges will say are probably going to be along the same lines. But the biggest stickler for me, and I'll just hit this one point and let the other judges talk, is know your local rules. So just as the Supreme Court has rules, you need to, especially down in Southern Illinois, where you're probably traveling to a lot of different jurisdictions, go to the website, know your local rules, call the judge even and see if the judge has, their own local rules of what they expect. Because for instance, in my situation, Madison County on the civil division, back when COVID first hit, we put in a standing order that indicated we're kind of getting rid of what we used to call the cattle call CMC dockets. Instead, we've put in place where any pending case, the parties will within 60 days enter a CMO order, and any new case within 60 days of an answer, you'll get together, still confer with the opposing counsel, and then enter an order. Well, I'm still having a lot of attorneys asking for CMCs, and again, I will give a CMC if you're not able to work out a scheduling order, but I always have to, and some of these guys have been around for a long time, and I'm like, have you looked at the March, or the May 2020 order? And they're like, oh, Judge, I didn't even know it was there. Local rules are there for a reason. So I guess that would be my number one tip for young attorneys, is just whatever jurisdiction you're going to, be familiar with the local rules.
I would echo Judge Smith exactly. I think the local rules are extremely important. And I think too, everybody's been in a situation where it's not your case, but you're covering for either a partner or you might be covering for another firm. I think judges understand that, but by the same token, you've got to know something. Otherwise, quite frankly, it's a waste of your time as well as the court's time. So know where you're at in discovery. Know if written is done or if there's something outstanding. Where are you on fact witness depositions, party deps, just even some of the basics, just for your own confidence as well as information for the court. It'll just make you feel better and more prepared to know a little bit about the case, even though you're not responsible for the case.
I would say that's true too. And a lot of times down in Southern Illinois, there may be a Chicago or St. Louis firm, like on a mortgage foreclosure, and then they have a local attorney appear just for a status and a lot of times the local attorney will say, Judge, I'm just here as local counsel. I don't know anything about the case. Well, that's not good enough. You signed on in the case, you're appearing in the case, even though you're just local counsel. You should have some familiarity with scheduling and what's going to happen next in the case. It doesn't buy you off to say, I'm just local counsel. That doesn't mean you signed the pleadings, you signed in, you appeared today, you filed an appearance. We have a local rule that says if you're going to appear, you have to file a local appearance. And if you file a local appearance, you're the attorney in the case for that day. So you're expected to do whatever's necessary with scheduling.
Yeah. And I would also say, not only just knowing your case, but reach out to opposing counsel, because if there's something that you can agree on before the status conference, judges love agreed orders. You might be able to save yourself a trip, especially with COVID. But I find it funny that, even especially in discovery disputes, I talked to them. I'm like, well, have you talked to the opposing counsel before this? No. Well, we're just bringing it up in front of you. So, not in addition to knowing the case, even if it isn't your case, always give opposing counsel a call and say, hey, what are your understanding of what we need to discuss, and see if there's any stipulations you can work out before then.
And you know what, I'm going to add to that. That's a huge thing. Mr. Connolly practices here in Kane County, so he probably knows this already from us. That's a huge thing up here. And whether it's COVID that has pushed the judiciary, or at least the civil judiciary, to that side or not, we don't need to see attorneys every 60 days just to come in and say, all right, yeah, here's what we're doing, and here's what we have 30 days from now and 60 days from now. We are promoting agreed orders. And obviously we're here if you need us, but otherwise we don't need to take up attorney time, spend client money just to come in to report that everything's okay. So we truly are trying to promote agreed orders prior to the next case management dates, and then not every 60 days. I'll see you in 90 days. I'll see you in 120 days. If obviously come in sooner if you need me, but otherwise just go ahead and work up your case.
How strict are you on case management orders to their deadlines? Because what I used to do is when they would come in on a case management conference and we would enter a CMO, I would say, is this a hard, fast order? Are you wanting to stick to this deadline? Or are we just kind of trying to feel our way through this case as we progress toward trial? If they said hard, fast, I held their feet to the fire. If we got near a trial date and they say, Judge, we think we need more time, I'm sorry, you said this is a hard, fast order. We're going to trial. And sometimes that promoted settlement. But if they're just kind of feeling their way along, I was flexible on saying, you need a continuance, fine, we'll continue it. You try your case at your speed. I was fine with that. But are you hard and fast with the deadlines, or do you give them some flexibility?
That's interesting. I will tell you up here, COVID has changed some of that because a lot of things are outside of the attorney's control. And I think we understand that at this point. But if I've got an old medical malpractice case, I just have done 2 trials this year that are 2014s. I don't have a lot of leeway on those cases. At this point, it's like, we're going to go. Either you can go ahead and dismiss it, or we're going to go forward. So I think it gets to a point where it's been long enough. And if you haven't done it yet, you knew this day was coming, and we are going to go forward. So I have some flexibility with the newer cases, and I understand some of the issues with getting medical records and things right now are really difficult. But some of the older cases, I think we're pretty hard and fast holding people's feet to the fire up here.
I would agree with that as well. And especially if I've given you a first out setting, then you better be ready to go. So I'm pretty strict, and especially if it's an expedited setting based on, the age of the parties, or, if someone's ill. Yeah, I'm pretty strict on that. But I would agree for some of the newer ones, if they're having problems, I give them a little leeway. But if you're first out on my docket, you better have a really good excuse why you're not going.
Great. Well, thank you. One of the things that kind of came out there is to know the local rules in each particular judge. And I think that's important for a new attorney, especially I remember for me, it was important to know that each county, each circuit, each judge does things a little differently. So I guess I'll start with Judge Bowles, since I've had the pleasure of being before Judge Bowles. Could you just kind of talk about what are the specific types of facts in the cases that you handle that you do expect attorneys to know, especially for like an initial case management conference? As I know you all talked about knowing the facts of the case, it might be helpful for some of these young attorneys to learn what specific things you're talking about.
I will tell you, in the civil world, for me, it's important. Sitting in law division, obviously you have a jurisdictional limit. The case needs to be in the right, it needs to be a law division case. The arbitration jurisdictional limit has been raised to 75,000 now. So one of the first things I'll ask is either what are the specials? So what are the medical bills in this case? Or if you don't know that, or a rough estimate, what's the injury? And where are we at as far as the injury? And if people don't, I understand you're not a walking dictionary, and you're not going to know, oh, this is this case, so we have 25,000 in medical specials, but know the injury. At least know, Judge, this is a death case, or this is a surgery case. It doesn't have to be down to the exact detail, but that's important. The other thing that's important is service. Has everybody been served in the case, or are we kind of jump starting because we only have 2 people served and we're waiting for 2 people? So know about service. And again, I think the last thing is just knowing what stage you're at in discovery. Who has what outstanding, because everybody kind of needs to move at the same pace. And so it helps if everybody hears it. A lot of times you'll have attorneys that'll say, oh, well, I thought I gave you that. I didn't think I had anything outstanding. So again, to know what stage and what your understanding is of the discovery is helpful to everybody.
And Judge Smith or Justice Vaughn, I know you've done some work on the criminal side of things too. Maybe could you touch base on what are the important facts to know on the criminal side of cases?
Go ahead,
I would say
Justice.
on the criminal side, I was a former prosecutor. I did some defense work, but there are certain deadlines on someone in custody, preliminary hearing deadline within 30 days, or preliminary hearing if they're on bail within 60 days. Vital to know the speedy, if you have a client in custody or a speedy trial demand has been filed, vital to know when that deadline is. I would say also, we have a case up on appeal. I was just reading briefs this morning. There's a dispute about someone requested a continuance, and they did it by email, but they never actually got an order from the court granting the continuance. The attorneys exchanged emails saying, hey, I'm going to ask to have this status conference continue. You okay with that? Yeah, no objection. but then they never appeared before the court. So the court never really granted an extension. So now they're fighting over, was there really an extension given? Why leave that up to the appellate court to decide that? Get it at the trial level, make sure if you have an agreement, then you go in front of the judge. And like Judge Smith said, we love agreed orders. I love it when an attorney would come to me and say, I've consulted with the other side. They have no objection. Here's an order to continue. Great, I'm signing it. I don't like it when somebody brings me an order to continue and they would say, we want to continue this case. Has the other side agreed to that? I don't know. I haven't talked to them.
Right.
Well, then we need a hearing. Either I want it in the order that says I've consulted opposing counsel and they have no objection, or else we have them on the phone, or they all appear. I don't like one attorney appearing asserting it's been agreed to when it's not set forth in writing in the file, because 60 days from now, I'm not going to remember that you told me it was agreed and they're claiming now that they didn't agree. There needs to be something in writing that says it's unopposed.
Absolutely. I think Judge Bowles actually hit the nail on the head for first CMCs. Those are excellent things that, attorneys should know for continuing CMCs. So let's say if you come back, closer, especially if I set you on a CMC for the trial date, you need to know if there's a CMO that's been entered. You need to know, are you ready for trial? If at some point you're a month or two out for trial and that you're not going to be ready to go, I'd rather know then. And I know a lot of times you're trying to push settlement, that sort of thing, but I would rather, you be upfront with the court, because then I can always give somebody else that first out, setting and move it along. But I think both the justice and judge made some great points on what to know at the onset.
I assume everyone knows when we're saying CMC and CMO that's case management conference and case management order. I don't know
if everybody knows that. Thanks.
Sometimes I go to education conferences and judges from Northern Illinois are throwing out these acronyms, and it's unique to Northern Illinois or unique to Cook County or something. And I'm just sitting there, even as a judge or an appellate court judge, my eyes still glaze over because I'm not familiar with their terminology. So that's another thing to be aware of the court you're going to when the judge asks you, do you have a CMO for me to sign? You know what they're talking about.
Right. I'm an Army girl, so we live off of acronyms. So my apologies. That's a great point.
So there's been a decent amount of discussion already about agreed orders. So I guess, Justice Vaughn, could you kind of begin our conversation on how important you think it is for counsel to work with opposing counsel ahead of status conferences and any court appearance to at least have a general idea of where things stand and come to at least some sort of an agreement, especially in today's world of Zoom hearings and all that.
Sure. Well, as has been mentioned several times, we always appreciate agreements as opposed to fighting. Sometimes attorneys appear in court and we're going to argue some motion. It turns out when they all get to talking, they were in agreement in the first place. So if they had talked ahead of time, that's one less thing we would have taken up trial court time for. It's one less thing to have to appeal or have to litigate later if you're already in agreement. Sometimes you're not that far apart. You save your clients money, and I think it just looks more prepared and more professional if you can. This is a profession. We are colleagues. I know some attorneys have a take no prisoners, death or victory kind of an attitude, but that's not the norm. Most attorneys are wanting to work together if we can and do what's best for your client. You're in it to help your client. If you're going to court needlessly and arguing and wasting time and money, you're costing your clients money. And I don't think anyone's in favor of that. You're there to perform a service for your client. So anything you can agree to is obviously better. And I can't think of the name. There's a paragraph that when you are having trouble reaching an agreement, that you're supposed to file a letter that says it's something K. The trial judge may.
201K.
201K.
Yeah.
Like I remember the K. I couldn't remember.
Yeah, but the interesting thing is that, a lot of attorneys, and this is just one of my biggest pet peeves. So anybody practicing in Madison County, it's a 201K conference. It's not a letter, and it is, a lot of people use it as a letter and they attach the letter. But in my mind, what I read that rule to say is you're picking up the phone and you're having a conference, because you know how it is. So oftentimes sending emails, or I sent a letter and then you pick up the phone because, and I'll just speak for myself, but I feel like most judges absolutely hate getting involved in discovery disputes, because most of the time, if you actually pick up the phone, work it out. But these letters, when they go back and forth, it's very frustrating to me when they're like, well, I sent them a letter. I'm like, well, did you pick up the phone and did you call them? I think oftentimes in the age of technology, we forget how easy it is just to shoot an email. And it's funny because the things that you say over email might not necessarily be the things you say either face to face or on the phone. And so I think you're a lot more willing to work things out if you pick up the phone. But yeah, Justice Vaughn, that was going to be one of my big things, is always, 201K, but remember it's a conference. And as far as, and then Judge Bowles, I'll let you talk. As far as battling it out, one of my colleagues and I, we were actually just talking, we're like, I don't know what they're teaching in law schools lately, but it feels like a lot of these brand new attorneys are coming out like they're in for an MMA match or something. I mean, they come in guns a-blazing and just wanting to destroy the other side. And truly, some of the most successful attorneys that I have seen have kind of saved those sorts of theatrics for the courtroom. They're very agreeable all throughout the case, and because they know their audience is the judge and we can kind of cut through some of that stuff. They save it for the trial, the actual trial. So I would just say, try and be agreeable, because the old adage is, you catch more flies with honey than you do vinegar. That's for sure.
And I'll take off on that, because I agree with that. And I think as far as speaking with the other side prior to coming into court, it helps promote civility. And it goes to what Judge Smith was just talking about. The younger generations are used to communicating by email, by text, definitely not by phone, definitely not in person, preferably for that generation. And I think the older generations that practice law will tell you that the benefit of coming to the courthouse was settling cases, because you would see people, you would talk to people. There was a congeniality, and so to not have that, and to have young attorneys starting the practice of law in a remote setting, it concerns me that they'll believe that this is how it's done and this is the best way to do it, because that doesn't promote civility. And I 100% agree with Judge Smith in the sense that you can really lose some confidence of a judge that you practice in front of if you're being obstinate just to be obstinate. I mean, it doesn't do anybody any good not to attempt to cooperate. That doesn't mean you're always going to get along and always agree on the issues, but to bring motions to compel and motions for sanctions the day after discovery is due, or the day, you just lose credibility in front of a judge, because it's kind of like, come on, can we all sit down and just talk this through? And why are you late? So it's really important to talk to the other side and do it audibly, and not over email and text and things of that sort.
Judge Bowles, and I think that's a good segue to my next question. In this world where we have less of an opportunity to be face to face, what is your advice to a young attorney that might be dealing with opposing counsel that it is being, kind of an obstructionist or not, cooperating in such a professional manner?
That's hard. I mean, it shouldn't change how you behave, except obviously you've got to progress your case. So even if it's an attempt to come into court to set up a settlement conference because you're not getting anywhere with trying to move things along just through your discussions, but to counter with the same type of obstinate behavior, and don't let that attorney turn you into that, because that's not going to get you anywhere. And all you can do is continue to meet your dates, continue to live up to what you owe, and as far as discovery, as far as sending out subpoenas, as far as noticing up debts. So when it comes time to be in front of a judge, you can say, hey, we've done this, this, and this. I've attempted to contact counsel on 3 different occasions. Unfortunately, I haven't gotten a call back. And there's a different way to communicate that. Instead of complaining and yelling at the other side, it's like, hey, judge, this is what I've done. I wish we were in a different spot, but we aren't. And here's what I've done to try and move things along and work with the other side.
I think one way to de-escalate to it, and probably every judge who's ever been in court has said this to the attorneys: address your arguments to me, don't address opposing counsel. That helps take some of the sting and the fire out of it. If you're talking to the judge, then you're going to be in a different demeanor and a different attitude. If you start looking across the table at somebody else and you're interacting back and forth with them, it becomes more argumentative and less civil. And so I think even if they're acting that way, if you address your comments to the judge, that helps, I think helps you come across better and more professional, and it also de-escalates some of the antagonism.
Yeah, because as Justice Bowles, or Judge, I keep calling you Justice, sorry, Judge. As Judge Bowles says, civility is everything, and your reputation, especially as a new attorney. So, you may be going up against somebody who's being, very defiant and very difficult. Well, especially if you're working in small communities, small counties, I guarantee you that judge probably knows the reputation of that attorney. So what you don't want to do, and this can kind of go into a lot of different areas about candor with the court and those sort of things, which I won't get into. But number one, your reputation, whether it be with the clerks, whether it be with other opposing counsel, the courthouse is like, there's ears everywhere. And if you, go at it with another attorney in front of one judge, you best believe the other judges are talking about what just happened in the courtroom. And so your reputation is everything. So it's best to start off on the right foot, take the high road. As Judge Bull said, just make sure your case is in line and don't stoop to their level, because I'm sure the judges already know, who the problem attorneys, as we call them, are.
And Judge Smith, that's another perfect segue. You mentioned the other court officials, and I'm assuming this will probably be an easy question, but what's your advice on how attorneys interact and deal with other court officials like bailiffs and clerks and that?
And I guarantee the other two judges will say this, but it's kind of like in the military. You always want to befriend your cooks and the people who process your paycheck. Never, ever, ever upset the clerks. I'm telling you, they can make or break your entire career. I mean, that was one of the best lessons my former partner gave to me is first thing you do, you go in, you butter them up, you know what I mean? You bring cookies on the holidays and you just, they will tell you, because there were so many times when I was a young attorney that would be like, hey, I mean, even small things, this is embarrassing to say, but I would go in and file a pleading or file a complaint because I was running up against a statute. And they're like, where's your answer? Where's your entry of appearance? Little things like that can make or break you. But as I mentioned, the courthouse has ears and the clerks are your number one ally. Or if you make them mad, they can be tough to deal with. So definitely treat them with respect.
There is absolutely no issue. 100% agree with that. And I mean, from clerks to bailiff to security to court reporters, just because you're paying a court reporter, you treat that person with respect, and they will help you in any way they can. Clerks can be so helpful, and clerks that like you will even go out of their way to do things and find out things in their office that they otherwise shouldn't or wouldn't for anybody else. So and they're, quite frankly, they're a great group of people that aren't paid enough and are working really hard. So it'll make you feel just as good as it makes them to just be really pleasant and civil to everybody in the courthouse.
Not only does it help your case go better, it may lead to future business. When somebody has a legal problem, they don't know who to call. They'll call the clerk, or if they have a friend who works at the courthouse, hey, who's an attorney who handles this kind of case? And if you've been hateful and mean, they're not going to recommend you. I can guarantee you that. So it may lead to future business. To be nice, I mean, as the older I get, the nicer I try to be. But there's no reason to. It costs no more to be nice than it does to be mean, and they're just there to do a job also. And I don't know why anyone would be mean to a bailiff or a court reporter or a clerk. As a judge, even now, I tell some of my colleagues, they get aggravated when some file's not where it's supposed to be, and I say, when you're running for retention, the public is going to ask, what's Judge Vaughn like? If they say he's hateful and mean, or I'd rather not talk about him, that sends a message. So if you're polite, and I know he's great to work with, he's pleasant, he's always prepared, he's there. Same with an attorney. They come to court prepared. They have their files in order. They communicate well with their client. That's the reputation you want to have. And that's what you want to have the clerks and the bailiffs and the court reporters saying about you. And they talk, they have friends. And even if they don't have friends directly, almost everyone's on social media anymore. And they'll share something in a DM or a private message that they may not put publicly, but social media is everywhere. And someone, if they know someone's a court reporter, say, hey, I've got a speeding ticket, or I'm going through a divorce, I'm going through a custody hearing, or I got rear-ended, who's an attorney I could talk to, or what kind of attorney is this? So they'll be communicating behind your back on social media, if no other way.
And kind of going to that first question that you asked, they're also great tools for if you are going to a jurisdiction that you don't know. And because, as we mentioned, every judge kind of has their different quirks on how they run things. Give them a call, give the clerk's office a call, find out who, my clerk is, or if they're not assigned clerks, hey, what do they expect? How do they run their docket? Is it a cattle call? Is it just whoever has got agreed orders? If you're a little bit nervous on that, they can be a really great asset. Both clerks and judicial assistants can help out in that way too.
sometimes it gets you in and out of court quicker too. In some counties, they just go down, there's a printed docket and they just go down in order. But in some counties, the clerk handles the docket. They'll say, Judge, here's the next case, and they can move you to the top or they can leave you at the bottom. So it helps you get in and out quicker.
Great. And Justice Vaughn, I'll start with you. Are there any, other than kind of the last couple topics we've been talking about, are there any ethical dilemmas or professional responsibility issues that a new attorney should be aware of in appearing in their first few court appearances?
I don't know, none come to mind directly in court. I would just say, keep a good calendar, keep a good record of when your deadlines are. If you miss something, obviously miss the statute of limitations, you're just going to be out of luck. But if you miss some other deadline, a discovery deadline or something, most people have had the same thing happen to them and they'll be accommodated. If you come into court and say, Judge, I was doing another trial, or I had another big case I was working on, I just overlooked this. Most judges, I think, are going to be understanding and give you some leeway, especially with a younger attorney. I would say too, don't make your first time to go into court be your case. Go with somebody else. If you're in a bigger firm and somebody's going to court, say, hey, can I tag along, be second chair? Can I come and observe, or can I go watch? Sometimes it's little things like, where do I sit? Where do I, do I stand when I talk? The small county I started practicing when I was state's attorney, the plaintiff in a civil case or the prosecutor in a criminal case had the seat closest to the jury box. The other side sat in the other seat. And if you haven't been to court before, you don't know where you're supposed to sit. And it's kind of a routine thing. The judge knows if you're sitting here, you're plaintiff's attorney. If you're sitting here, you're defense attorney. And so some little things like that, go with someone else and they can kind of tell you, show you the ropes where you should be. But I don't think I would go to court cold. The first time I ever went to court be my case. I think I might go and observe someone else the first time. And I think as Judge Smith said before about your reputation, once you ruin your reputation, it's very hard to get it back, and it takes a long time to get it back. So if you mislead a judge in court, if you have something you missed, or the facts aren't on your side, but you fudge on the facts, that's going to stay with you for a long time. The judge is going to learn that I can't trust what you say. If you come to court and say this is unopposed and turns out it was opposed, the judge is not going to forget that. So those are the only ethical issues that come to mind immediately to me.
And that's exactly what I was going to say, just what Justice Vaughn had focused on. The fact that whether it's in briefs, whether it's in oral arguments, if you are trying, you can always argue how you see a case and how it might be advantageous to your client. But if you're overstating really what a case represents, or you're not giving the correct history of the case, that will clearly stay with that judge forever, that I can't trust what is coming out of either their mouth or what is being written. And to be honest, again, if you blew a date, if the reason that discovery is late is because you can't find your client, don't fudge, be honest about it. The best thing for a judge is that they can take to heart what this attorney in front of them is saying, and that they don't have to try and read through the lines, or quite frankly, just discount it because this attorney has earned a reputation where they're not 100% honest and won't look at it objectively. Another thing is a case, if you're briefing something and there's a case out there that's against you, offer it up. You can say, hey, I know this case exists, but here's why. In this case, it doesn't apply to me. But Judge, with all candor, I realize it's there, and so that goes a long way.
That's funny. That was on my notes to make sure to say I hate it when attorneys want to hide bad case law. It's like they've taught us how to distinguish cases, but don't hide bad case law. Throw it out there. It's much better. It's, as they mentioned with trial strategy, it's better to get the bad stuff out first and then distinguish it. Tell me why it's different. Along those lines, as far as ethical responsibilities, one of my biggest pet peeves is, especially in motion practice, and a lot of times it's mostly the plaintiffs, because I know, defense counsel, you're billed for your work, plaintiffs counsel sometimes not. But, the saying that I have is any motion is good until I read a response. And if you're not filing responsive pleadings to these motions for summary judgment, and then you're just coming in and arguing it, I can probably speak for the other two judges on here. We actually read these motions. We get into these motions before the arguments, and you need to have a response in writing on there, and don't come into court, or if you need some more time and if you need a briefing schedule, then you need to request that from the court. But I think that's one of the biggest mistakes I see plaintiffs make, is that they don't file a written response to really substantive motions.
Great, thank you. We've talked a lot today about kind of the changes in our system over Zoom and all that due to COVID. Judge Bowles, are there any other changes going on in the legal system or court system over the past couple of years, or in the future, that you think will be coming soon that a new attorney should be prepared for, other than Zoom?
Well, I think that it's all speculative somewhat at this point, but I will tell you, I think even just serving on the Illinois Judicial Conference, where we had to, in essence, put together strategic agenda for the judicial branch for the next 5 to 7 years. Part of it was a takeoff on what we've had to deal with this last year and the forced technology upon us, and how we can continue to better that, whether that's justice going to the people in like a traveling van, or a road show where judges go different locations. I think that the younger attorneys coming on now will be better equipped to adapt to what the judicial branch is going to be doing over the next few years. And I hope that we continue to push the technological boundaries, only because we were so far behind when we were forced to catch up, that now I just hope we don't get that far behind until another pandemic comes along. So just that we don't forget what we've learned, and we can kind of continue to allow access to justice, or better access to justice, in different ways using technology and what we've learned this past year and a half.
Justice Vaughn or Judge Smith, would you like to add to that? Or
I think Zoom is here to stay. I mean, you said besides Zoom, but when I was a prosecutor, well, even when I was a judge, we would have somebody come in town for a wedding, they get a DUI, and they live in Colorado. And then we used to make them have to travel back to Illinois to enter a plea, when it's pretty much a standard deal. First offender DUI was a standard deal. Now with Zoom and some of the relaxed standards, those people can appear remotely. So I think that's going to stay even when COVID and this is all behind us. We will still have occasions where you appear remotely on video on Zoom. We just saw this in the last 2 weeks. I think the Supreme Court adopted a policy where every circuit or every county is to adopt their own cell phone policy, whether you can have phones in the courtroom, or who's allowed to have a phone in the courtroom. So we're going to see changes of that nature going on. We didn't really talk about much, but when you're in court as an attorney and you're doing case management conferences or scheduling, you should have dates ahead of time. You should have talked to the opposing counsel and have dates in mind ahead of time, or gone down to the clerk's office and scheduled some. But it's not unusual to have an attorney say, "Can I check my office?" And they text home, or text the office, or call the office, or step out of the courtroom and call. So I think smartphones are way more impressive than when I first started. We had a bag phone in the car. Now you have a whole computer in your hand that's probably more powerful than the computers that sent rockets to the moon. So the access you have to information and legal research like Westlaw or Lexis on your phone, all that is going to just keep improving. So I don't know what else to say about that. I think the courts are going to be trying to adapt. When you see the Supreme Court and the appellate court, it's usually older people who have worked their way through the system and near the end of their careers. So we don't adapt to the technology quite as well. We're a little bit behind the technology, but I think the court is trying to show through EdCon and other things that we are trying to get more modern and adapt to be more accommodating to attorneys and parties, litigants, pro se litigants, trying to make court more accessible and more friendly.
I think Justin Vaughn's right. Flexibility is the key. Yeah, I think that's one thing COVID has taught us. And so as far as future goes, it is difficult to predict, but flexibility is the key. And I think, the older you get in your career, the harder it is. I mean, I still love hard copy documents that I can highlight and sticky notes, and I'm trying to adapt more to reading things on the iPad and that sort of thing. But I think the younger generation, this younger group of attorneys, because you have gone through, COVID, I think you're more willing to be flexible on what does lie ahead.
With that in mind, though, I would say too, when we were talking to the circuit clerks and court staff, the mentor program, I think Judge Bowles or Judge Smith is part of the mentor program. I was a mentor at one time, and talked to some of the court staff about who's an experienced attorney who can help me. You don't have to do this on your own. And sometimes we do things, that's the way we've always done it for a reason, because there's a rule that requires it, because this is the way that works or whatever. Reach out to an older attorney or an experienced attorney and take advantage of their knowledge. I suspect they would be flattered if you say, I talked to the circuit clerk and they recommended I talk to you about this. They would be flattered that they were recommended, and it would give you an end to years of experience you might not otherwise have access to. So.
One thing that I'll say for young attorneys too, that the more you're in the courtroom, the more comfortable you're going to feel. So to step outside your comfort zone, I think we all remember I started at a large firm down in Cook County, and it was terrifying going to the Daily Center the first day. All the judges knew that the new attorneys were going to be there, and and it was a humbling experience. But again, to step outside your comfort zone and to get into a courtroom, and you'll just feel more and more comfortable each time you do it. And if you have a mentor or somebody whose style you like, to go sit and watch a jury trial and see what works, see what doesn't work, watch the jury and see how it resonates with a jury. I mean, there's no better teaching really than to see a trial at work and see what a good cross-examination can do, and what preparedness can do, quite frankly.
Along those lines, this was kind of another, I remember just being a brand new associate and just passing the bar, the Missouri bar as well. And I remember one of the law firm partners coming up to me and he's like, Sarah, I know you're kind of riding this high from passing the bar exam, but you really don't know what you're doing until you've been an attorney for about 5 years. And it was kind of a deflating moment, but now looking back on it, it's so true. And, I think, heck, it probably took me that long to understand the difference between a 2-6-15 and a 2-6-19 motion. So don't get frustrated, because we've all been through that learning curve. And as Judge Bowles said, the more you're in and the more you're watching and the more you're just absorbing it all, some of you might take less than 5 years, but for me, it was 5 years before I was really like, hey, I've got my feet, the ground underneath me, I'm ready to go. But don't get discouraged, because the stuff that they teach you in law school is a lot different than the actual practice of law.
And we only have a few more minutes, but I'll ask kind of a final question to you all. Is there something that you wish you knew as a young attorney, looking back in your career now, that you wish you knew then, or anything that we haven't covered today that you think would be helpful for a new attorney to know? And Justice Vaughn, we could start with you.
I'm tempted to say to learn how to be an engineer instead of an attorney. Both my sons are engineers, and they tell me that's who really runs the world. They're the smartest. I tell them when engineers screw up, they come to court and lawyers fix it for them. But I think just the idea of bar associations, friends, going to meetings. It's not always what you learn at the meeting, it's the relationships you build. And when I was a young state's attorney, it was mentioned earlier, I was 26 years old. I was just out of law school. I had just graduated while I was running for office, and was actually elected before I was sworn in. But I felt like I was on an island. But there were people out there. When I went to the state's attorneys conference, there were other state's attorneys who were glad to give me information and give me forms and give me help. And when I started my private practice, I was a small town attorney, but there were other attorneys who, when I was doing a title search or a title opinion, they would give me forms and give me ideas, things to look for. And there is, through your bar association, whether it's the Illinois Bar Association or your local county bar association or regional bar association, there are people out there who want to help you and want you to do well. It doesn't do the profession any good to have an attorney out there messing up and giving us all a bad name. They want you to do well. They may want to beat you in court, but they still want you to do well and do the best you can do. I referee basketball games now. When you go to a game, and I coach high school golf, we want the opposing team to do well. We just want to do a little better. I don't want to see a game or a golf match where somebody's making bogeys and hitting balls out of bounds and doing stuff. I want them to do well, and I want to do a little better. So I think attorneys, the good attorneys, want you to be good also. They want to go against good attorneys, and they want to have good attorneys in court. It makes the thing work so much more smoothly when everyone is prepared and professional and does a good job. So there are people out there who want to help you if you'll reach out to them. I didn't know that in the beginning. I kind of learned it along the way, but I would say that.
You know what, I think that's a good point. And I think too, if somebody would have told me that you can control your own destiny in a profession that is stressful. I mean, we need to call a spade a spade. It's a stressful profession. It's hard to make a living in certain areas in this profession. And and to develop good habits right at the outset, as far as preparedness, as far as completeness, as far as communication, whether it be with clients, with opposing attorneys. Again, that will be something that will follow you, and to be able to help create the profession that you want to work in, so it is less stressful. So the civility, like Justice Vaughn talked about, reaching out to other people, working with other attorneys in your community on the state level, it all folds into the profession and will make it a better and more pleasant experience for you overall.
Agree. I want to echo that. Sometimes, we get too caught up in the grind and then we forget our own self-care and mental health, and kind of along those lines, find something in your community outside of the legal profession that you're interested in and passionate about. That would be probably my number one. My number two, and unfortunately I learned this once I became a state's attorney and I couldn't do pro bono work, but get involved with some of your pro bono committees. There are so many out there. Some of them focus on specific things. There's ILAFLAN, which is helping veterans. There's somebody have to help me up north. I think it's Prairie State Legal Aid.
Yep,
I know
Prairie State's.
Land of Lincoln down here. There's all sorts. PILI, which is kind of embracing all of it. Get out there, because number one, it'll give you an opportunity to meet people outside of your area of practice. Number two, you'll actually be doing something good and giving back to your community. And number three, it just kind of helps just from the daily grind. So I wish I would have, I know some, if you're in government, sometimes you're a little bit limited on what you can do, but definitely I think most of the larger firms and even the PI firms encourage that with their associates. Get out there and do some pro bono work.
I don't know how much time we have left, but one other thing that occurred to me is a lot of times we get so used to going to court as you progress as an attorney that you think that this is just a routine case, but to your client, it's not a routine case. It's their one time to go to court. I have here, I don't know if you can see this, but I when I was a prosecutor, I had a case, a child abuse case. And when it was done and we got a conviction, child sex abuse case, the two little girls came to my office and they gave me this precious moment. And I don't know if you can see it. It's an elephant with a string tied around its nose. And the name of the precious moment is "How Can I Ever Forget You?" And that was in 1991. I still have it, but it's an important case to them. It meant a lot to them that somebody was speaking for them in court, whether it's a child case or a custody case or a medical malpractice case or an insurance case, whatever kind of case. Most people don't go to court just willy-nilly. They go to court because it's something important to them. So it may be routine to you, but it's their day in court. So just keep in mind that there is no routine case to your client.
Great. Well, I thank you three for your time today and for giving us your insight and advice for everyone. So I guess I'll turn it back to Phil.
Yeah, thank you guys so much. Super information there. And we just really want to thank you again for your time and being flexible with us. I know we had to change the date on you guys due to some COVID issues and things like that. So thank you all again. Thanks for those who are participating. I just want to end with the fact that this is being recorded, so we will be able to watch it. And we do have quite a few people who watch who aren't able to attend during lunchtime. So that's always the case. And our next food court event will be March 9th, coming up here soon. So thank you all again and have a wonderful day.
Thank you.
Thank
you.
you.
Judges, appreciate everything. Thank you so much for your time.
No
Thank you.
problem.